Did you know that thousands of people are expelled from Canada every single year? And starting in September 2025, the number could rise even higher? The government has quietly introduced new immigration rules that give officers more power than ever before to cancel permits, visas, and authorizations. What's shocking is that it's not just criminals or fraudsters at risk. Ordinary students, workers, and visitors could also find themselves suddenly out of status and facing removal, sometimes for reasons as simple as a paperwork error or missing a deadline. Imagine spending years building your future in Canada, only to be told you have just days to leave. These changes are creating a wave of fear and uncertainty, and the details aren't always easy to understand. So who exactly is at risk of expulsion under these new rules? Stay with me, because in this video we'll break down 10 key rules you need to know. Number 10. Delay, lack of application or restoration, failing to renew. One of the most overlooked but dangerous mistakes that can lead to expulsion from Canada in 2025 is simply failing to keep your immigration status valid. Under the new rules, if you don't apply to renew your permit on time, whether it's a study permit, work permit, or visitor record, you can immediately fall out of status. Once that happens, you're technically in Canada without legal permission, and this gives immigration officers the right to cancel your documents and even issue a removal order. Many people assume that a short delay or missing the deadline by a few days isn't a big deal, but Canada's immigration system is becoming stricter, and these minor oversights can now have major consequences. The government does provide a safeguard called restoration of status, which allows people who lose their status to apply to restore it within 90 days. However, not everyone qualifies, and restoration is not guaranteed. Plus, it often comes with extra fees and additional scrutiny of your case. Imagine you're an international student whose study permit expires in August and you forget to apply for renewal. Even if you realize your mistake a month later, you'll need to go through the restoration process, and during that period, you may not be legally allowed to study or work. This can disrupt your education, employment, and long-term immigration goals. The safest way to avoid falling into this trap is to track your permit's expiry dates carefully, set reminders, and apply for renewal at least 30-60 days before your status runs out. If something unexpected happens, like your documents getting delayed or lost, seek professional advice right away. Don't assume you'll be given extra time. Canada's new immigration framework is designed to reward those who are organized, proactive, and compliant. Before you move on, here's a question for you. Do you know exactly when your current permit or visa expires? If not, check it today and mark it on your calendar. And if you found this explanation helpful, don't forget to like this video, subscribe to the channel, and drop a comment about your own experiences with renewals. We'd love to hear from you. Number 9. Non-compliance with permit conditions. Another critical reason people may face expulsion under the 2025 rules is non-compliance with the conditions of their permit. When you enter Canada on a student permit, work permit, or visitor visa, you're agreeing to very specific rules. These might include how many hours you can work, what type of job you can take, what institution you must study at, or how long you can stay in the country. If you break even one of these conditions, immigration officers now have broader authority to cancel your documents and issue removal proceedings. For example, international students are often restricted to working a limited number of hours per week during the academic term. If a student is found working full-time without authorization, that is considered a violation. Similarly, a temporary foreign worker who takes on a second job outside the scope of their permit is also in breach of their conditions. Even visitors must comply with the rule that they cannot work or study without the proper permits. These may seem like small shortcuts, but under the new regulatory framework, Canada is placing stronger emphasis on compliance to protect the integrity of its immigration system. The government has also introduced technology and data sharing systems that make it easier to catch violations. Employers are required to keep records, schools report on enrollment, and border services may review travel patterns. This means that even if you think no one will notice, the risk of being caught has grown significantly. Once you are flagged for non-compliance, it doesn't just affect your current status, it can impact your future applications, making it harder to return to Canada later on. To stay safe, it's essential to know exactly what your permit allows and prohibits. Read the conditions carefully, ask questions if you're unsure, and never assume how can bend the rules. In 2025, compliance is not optional. It's the foundation of maintaining your right to stay in Canada. Number 8. Biometric or security changes. In 2025, one of the stricter grounds for expulsion from Canada relates to biometric or security changes. When you apply for a visa, study permit, work permit, or even an ETA, you're required to submit biometric data such as fingerprints and photographs, as well as pass background and security checks. These measures are designed to confirm your identity and ensure that you don't pose a threat to public safety. However, the new rules make it clear that if there are changes in your security status or concerns with your biometrics, immigration authorities have the power to cancel your documents and begin removal procedures. For instance, if new information surfaces linking an individual to criminal activity, fraudulent documentation, or associations with groups considered a security risk, their legal status in Canada can be revoked, even if they were previously approved. Similarly, if biometrics are found to be falsified or don't match updated identity records, this can trigger an immediate investigation. Canada has invested heavily in data sharing agreements with other countries, which means that information about arrests, convictions, or even ongoing investigations abroad can now be flagged across borders. It's also important to understand that biometric requirements are not a one-time process. In some cases, individuals may be asked to provide updated biometrics for renewals or when extending their stay. If you refuse or fail to comply, your documents may be invalidated. Moreover, if you develop medical or health issues that are considered a public safety or security risk, this too can result in a reassessment of your admissibility. The key takeaway is that Canada's immigration system is becoming more dynamic and responsive to new information. Approval today does not guarantee indefinite safety. If your circumstances or background change, or if new data emerges, your eligibility can be reassessed. For anyone living or studying in Canada, this means maintaining transparency, staying compliant with requests for updated biometrics, and ensuring there are no security issues that could jeopardize your stay. Number 7, administrative errors in issuance. Another situation that can lead to expulsion under the 2025 immigration rules is when a permit or visa was issued because of an administrative error. While this might seem unfair at first glance, Canada's immigration system relies on accuracy and proper documentation. If a visa officer, for example, mistakenly approves an application despite missing information, incorrect eligibility assessment, or a clerical mistake, the document can later be canceled once the error is discovered. This cancellation is not a reflection of fraud by the applicant, but the individual may still lose their legal status and face removal if the mistake is not corrected quickly. Imagine a work permit being granted without the required labor market assessment attached, or a study permit issued without confirming the school's eligibility as a designated learning institution. These kinds of errors sometimes happen due to the large volume of applications processed every year. Under older systems, such mistakes might go unnoticed or be overlooked, but with the new 2025 framework, the government has empowered immigration authorities to actively review past approvals and correct errors, even if it means canceling valid-looking documents. The impact of these administrative cancellations can be significant. A student may suddenly discover that their study permit is invalid because it was issued in error, forcing them to stop classes immediately. A worker may find that their employment is unauthorized despite having what appears to be a valid permit. This not only interrupts careers and education, but also creates a stressful and uncertain environment for individuals who acted in good faith. To reduce the risks, it is important for applicants to double-check every detail of their approvals and keep copies of all correspondence with Immigration, Refugees and Citizenship Canada, IRCC. If an inconsistency is noticed, addressing it proactively with immigration officials or seeking legal advice can sometimes resolve the issue before it escalates into a cancellation and possible expulsion. In 2025, vigilance is essential even when the error is not your own. Number 6, automatic cancellation on becoming permanent resident or death. Under the updated 2025 immigration rules, certain situations lead to the automatic cancellation of temporary documents without any appeal or delay. Two clear examples are when a person becomes a permanent resident or in the unfortunate case of their death. These rules are not meant to be punitive, but rather to maintain the integrity of Canada's immigration records and ensure that individuals are only holding the status that applies to their situation. When someone transitions from a temporary resident to a permanent resident, all previously held documents, such as a work permit, study permit, visitor visa, or electronic travel authorization, are automatically invalidated. This is because once you are a permanent resident, you no longer require temporary documents to live, study, or work in Canada. Continuing to hold or use these old documents could create confusion, duplicate records, or even open the door to misuse. The system therefore cancels them to avoid any overlap and to establish a clear, singular status for the individual. In the case of death, cancellation of immigration documents is an administrative necessity. Authorities must update records to prevent fraudulent use of the documents by others. While this might sound obvious, Canada processes a vast number of permits and visas each year, and automatic cancellation ensures that the system reflects reality and remains secure. Although these scenarios might seem straightforward, they do carry practical implications. For example, individuals waiting on their permanent residency approval should be prepared for their temporary status to end as soon as their new status is confirmed. It's important to plan for any transitions in employment, travel, or studies during that period. Likewise, family members of deceased individuals are often responsible for notifying authorities to ensure that records are updated promptly. The key lesson from this rule is that Canada's immigration system is designed to maintain clarity, accuracy, and security. Holding only the status you are entitled to helps prevent errors, fraud, and unnecessary complications in the future. Number 5. Lost, stolen, destroyed, or abandoned documents. One of the less obvious but equally important grounds for cancellation under the 2025 immigration framework is when immigration documents are lost, stolen, destroyed, or abandoned. These documents, whether a study permit, work permit, visitor visa, or electronic travel authorization, are the official proof of your legal status in Canada. Without them, immigration officers cannot verify your rights, and this creates a serious risk of misuse or fraud if the documents fall into the wrong hands. For that reason, Canada has made it clear that any such documents will be considered invalid and subject to cancellation. Imagine, for example, a worker whose permit is stolen along with their wallet. If the document is not reported, someone else could potentially try to use it fraudulently. Similarly, if a study permit is accidentally destroyed or misplaced and not replaced promptly, the individual may no longer be able to prove their legal right to remain in Canada. In some cases, people even abandon their documents by leaving them behind during travel or discarding them without realizing the legal implications. All of these scenarios now fall under the tightened rules, leading to automatic cancellation once the loss or destruction is confirmed. The consequences of having documents canceled can be significant. A student could be prevented from attending classes, a worker could lose authorization to continue employment, and a visitor could suddenly be flagged as being out of status. This can trigger not only disruption in daily life, but also possible removal proceedings if the situation is not corrected quickly. To avoid such complications, individuals are strongly advised to safeguard their permits and visas at all times, make copies of important documents, and report any loss or theft immediately to both local authorities and Immigration, Refugees and Citizenship Canada, IRCC. By taking quick action, you can request replacements and ensure your record reflects that the missing document is no longer valid. In 2025, being proactive about protecting and reporting your documents is essential to maintaining uninterrupted legal status in Canada. Number 4. Failure to depart. Overstay risk. One of the most serious triggers for cancellation and expulsion under Canada's 2025 immigration rules is the failure to depart on time or when there is a clear risk of overstaying. Every temporary visa, study permit, or work permit comes with a fixed expiry date, which defines the maximum period an individual is legally allowed to remain in Canada. If you stay beyond this period without applying for an extension or change of status, you are immediately considered out of status, and this can lead to removal orders. What makes the 2025 update stricter is that even if you have not yet overstayed, but immigration officers believe you might not leave when required, they now have expanded authority to cancel your documents in advance. This rule reflects Canada's growing concern about individuals using temporary permits as a way to remain in the country indefinitely without following the proper pathways to permanent residence. For example, a visitor who has no clear return plan, no proof of ties to their home country, or insufficient financial support may be seen as a high overstay risk. Likewise, a student who stops attending classes or a worker who loses their job but continues staying in Canada without applying for a change of status could face document cancellation even before the official expiry date. The consequences of overstaying are far-reaching. Not only can it result in immediate removal from Canada, but it can also create a long-term ban on re-entering the country depending on the circumstances. In addition, overstays become part of your immigration history, making it harder to apply for future visas in Canada or even in other countries that share immigration data. To stay compliant, it's critical to monitor the validity of your documents, prepare for departure in advance, and apply for extensions well before your current rent status ends. Canada's system is increasingly focused on ensuring that temporary residents remain temporary, and failing to respect this condition now carries harsher consequences than ever before. Number 3, change in circumstances on status. Another important ground for expulsion under the 2025 rules involves a change in circumstances or status that makes a person no longer eligible to hold their current immigration document. When Canada issues a study permit, work permit, or visitor visa, it does so based on specific information provided at the time of the application. If those conditions change significantly, such as your job ending, your program of study being discontinued, or your personal circumstances shifting, your original eligibility may no longer apply. Under the new framework, immigration authorities now have broader powers to cancel documents once these changes are detected, even if the person hasn't deliberately broken any rules. For instance, if a temporary foreign worker loses their job, they can no longer legally remain in Canada under the work permit tied to that employer. Similarly, if a student transfers to an institution that is not a designated learning institution, DLI, or drops out of their program altogether, their study permit can be revoked. Even personal events like a change in marital status or family composition may alter eligibility for certain dependent visas. These changes do not necessarily mean someone acted dishonestly, but under the updated system, the failure to maintain the original conditions can still result in cancellation and possible removal. The impact of this rule is particularly challenging because some changes are sudden and beyond an individual's control. A company may shut down, a program may be discontinued, or family situations may evolve unexpectedly. Despite this, the responsibility still lies with the permit holder to notify Immigration, Refugees, and Citizenship Canada, IRCC, of any major change and to apply for the correct new status if needed. In 2025, Canada is emphasizing that immigration documents are dynamis, IC, not permanent. They remain valid only as long as the circumstances that justified them continue to exist. This means staying vigilant, being proactive about reporting changes, and ensuring that your immigration status always matches your real-life situation. Number 2, criminal history. Inadmissibility. One of the strongest and most clear-cut reasons for expulsion from Canada under the 2025 immigration rules is linked to criminal history and inadmissibility. Canada takes the issue of public safety very seriously, and even minor legal troubles can have major immigration consequences. Under the new regulations, if someone is found to have a criminal record, becomes involved in criminal activity while in Canada, or is flagged for security or health-related inadmissibility, their temporary resident documents can be immediately canceled. This applies not only to serious crimes such as assault, fraud, or drug trafficking, but in some cases also to offenses that might be considered less severe in other countries, such as driving under the influence. The rules also extend to individuals who were not fully transparent about their criminal past when applying for entry. If background checks or international data sharing systems reveal previously undisclosed convictions, the person may face cancellation of their visa or permit, even if they have already been living in Canada for some time. Likewise, those who commit crimes after arriving in Canada place themselves at direct risk of removal, regardless of their study, work, or visitor status. Beyond criminal conduct, security-related concerns, such as links to organized crime, terrorism, or activities that threaten Canada's national interest, also fall under this category of inadmissibility. Health concerns can also play a role, particularly if someone develops a condition that is considered a danger to public health or safety. While not all medical issues result in inadmissibility, the updated framework allows immigration authorities to reassess eligibility if a situation is deemed to pose a broader risk. The consequences of being found inadmissible are severe. Not only can it result in immediate expulsion, but it can also affect a person's ability to apply for future visas or permanent residence. In some cases, individuals may be banned from re-entering Canada for several years. The key lesson is that Canada expects transparency, lawful conduct, and compliance at all times, and failing to meet these standards leaves no room for leniency under the 2025 system. Number 1. False or misleading information. One of the most common and serious reasons for expulsion under Canada's 2025 immigration rules is the use of false or misleading information. When applying for a study permit, work permit, visitor visa, or electronic travel authorization, applicants are required to provide accurate details about their identity, education, employment history, finances, and personal background. Even a small misrepresentation, whether intentional or accidental, can be treated as misrepresentation, leading to immediate cancellation of immigration documents and potential removal from the country. This rule applies not only to outright fabrications such as using fake academic transcripts or forged job offers, but also to omissions. For instance, failing to disclose a past visa refusal in another country, hiding a medical condition, or downplaying gaps in employment history can all be considered misleading. Under the updated 2025 framework, Canada has strengthened its verification processes, using advanced data sharing with foreign governments, educational institutions, and employers to cross-check information. This means that discrepancies that might have gone unnoticed in the past are now far more likely to be detected. The consequences of being caught providing false or incomplete information are severe. In addition to losing current status, individuals can face a ban of up to 5 years from reapplying to Canada. This can derail long-term plans for studying, working, or immigrating permanently. Moreover, a record of misrepresentation may affect applications to other countries, since immigration systems increasingly share information across borders. What makes this rule especially challenging is that not all cases involve deliberate dishonesty. Sometimes applicants make mistakes due to confusion, language barriers, or poor advice from unregulated consultants. However, under Canadian law, the responsibility always falls on the applicant to ensure the accuracy of their submissions. In 2025, the message is clear. Every detail matters. To remain safe, individuals must be diligent, transparent, and truthful, as even minor inaccuracies can jeopardize their future in Canada. As you can see, Canada's 2025 immigration rules are stricter than ever, and even small mistakes can lead to cancelled documents or expulsion. Whether it's overstaying, misrepresentation, or failing to renew on time, the consequences are serious and long-lasting. Staying informed, organized, and compliant is the best way to protect your future in Canada. If you found this video helpful, don't forget to like, subscribe, and share it with anyone who might benefit. Drop a comment below with your questions or experiences, and check out our other videos for more tips on navigating Canada's immigration system safely.